Okay, we're going to move on to section 547C2, commonly known as the ordinary course of business defense. So this reminds me of like a chess defense, the Sicilian defense, the ordinary course of business defense. Anyway, we'll go into the elements and see how it works or doesn't work. Anyway, that's the policy everyone keeps repeating. I'm not going to comment on it because I don't really think it's true. And I did a whole slideshow called The Truth About the Preference Laws, explaining why I don't think it's true. But let's move on. It's not really germane to our purposes, except to know the policy exists. Okay, well, we're going to look at each element. To the extent that such transfer was in payment of a debt incurred by the debtor in the ordinary course of business or financial affairs of the debtor and the transferee. So what does that mean? Basically, it means that the ordinary course exception is about ordinary trade credit transactions. So let's take a look at a case. Okay, so 547C2, the beginning of 547C2 addresses debts incurred by the debtor in the ordinary course. 547C2A addresses transfers that were made in the ordinary course of business or financial affairs of the debtor and the transferee. So what does that mean? What does 547C2A mean? Thousands of cases have focused on what this means, and probably hundreds of millions of dollars have been spent litigating this subsection. So let's take a look. This is an older Court of Appeals case of the 11th Circuit. I use this case for a couple of reasons. In this case, defendant supplied gas to the debtor, a gas station. And what happened here was that the vendor started getting paid later than usual during the preference period. Payment was due in 10 days, and it was getting paid in well over 10 days, well over 16 days. The vendor and the debtor testified that it didn't consider 16 days to be late, but these payments were made well over 16 days, and they were made by certified check. What was interesting about that is that the gas station wasn't even using Craig oil during the preference period. So why was it paying these late payments by certified check? Why was it paying them at all, really? Because it wasn't really buying gas from them anymore. And the answer was that the defendant had threatened the debtor with an involuntary bankruptcy petition. Another creditor was recruiting other creditors to file an involuntary. And one of those creditors that it was recruiting was this particular vendor. And the vendor said, hey, pay up or we're going to put you in an involuntary bankruptcy. Of course, the creditor claimed, well, these payments were really not that late and they were all in the ordinary course. And the bankruptcy court disagreed. And the district court disagreed, and the Court of Appeals court disagreed. And what's interesting about this case is that the district court went into the changes in the bankruptcy code, the changes that were made in the bankruptcy code in 1978 as opposed to the Bankruptcy Act. One of the important changes that was made is that the trustee no longer had to show intent on the part of the creditor. Under the Bankruptcy Act, the trustee would have to show that there was an intent to be preferred. And under the Bankruptcy Code, that was taken out. And the reason it was taken out is that the theory was, well, we're not going to show that you were preferred because you are preferred. In other words, there was a different analysis that was used in 547B. If there was insolvency, and other elements for 547 were met, you're preferred because you're getting a bigger piece of the pie. What's interesting and what's confusing is that, well, is intent completely irrelevant now? Was intent taken out of the code completely? And I thought this case was interesting because it said, no, intent, the debtor's state of mind, is still relevant. It's still material or not immaterial for the purpose of showing what the debtor's motivation was in paying a creditor, maybe what the motivation was on both parties in this case. And so it found it relevant to determining that no, this was not ordinary course, that this was one vendor applying a great deal of leverage, in fact, threatening to put the debtor into involuntary bankruptcy. And that's why they were paid. And also that they were paid with certified check, and they were never paid with certified check before. And so the combination of the facts and circumstantial evidence of the debtor's intent in making the payment was enough to take it out of the ordinary course. What I thought was interesting about this case, I mean, you have a certified check where you never had a certified check before. What was interesting to me is that the court explicitly ruled that intent was not immaterial in its conclusion, that it was not an ordinary course transaction. And that can be very confusing. A lot of cases state that intent is not relevant, and it may not be relevant to determining whether there was a preferential payment, because that's a simple question of whether the debtor was insolvent and whether there was a later bankruptcy filing within 90 days and other elements. But it may be relevant to determining whether the payment was made in the ordinary course. Craig Oil found that late payments are particularly important in deciding whether the ordinary course defense applies, but a later Court of Appeals case found that late payments can be ordinary if they're found to be ordinary in the course of dealings of the party. If late payments are common, then even late payments can be found to be made in the ordinary course and protected by the ordinary course defense. And that's what happened in this case. I thought this case was interesting because the payments were very, very late. Here the payments, Tulip was a supplier of paints to the debtor, and they got paid routinely in 90 days, way over terms. Trustee moved for summary judgment. The defendant responded with a cross motion for summary judgment, and the court ended up finding for the defendant. What's interesting is why. The court observed that you have to establish a baseline of dealings. In other words, a comparison period prior to the preference period, and the court will compare that to the preference period and decide whether the payments during the preference period are ordinary. What's ordinary? What's ordinary between the parties is what was between the parties. What was the behavior? That's what's ordinary, whatever that was. And then compare that to what happened during the preference period. A couple of different kinds of typical arguments were made. One was that what's called the range argument, that payments during the comparison period were made in a range from 27 to 176 days. And during the preference period, the range was between 90 and 98 days. So why is that important? Because the payments were within range of the payments made in the base period. Also, averages were taken. That's also a common way to argue ordinary course. And here, during the preference period, the average was 93.42, and during the base period or the comparison period, the average was 87.36. And the court looked at these numbers and decided, basically, these guys always paid very late, and that trend continued. The court also found that there was no unusual collection activity during the preference period. So the court granted the summary judgment motion of the defendant in this case. It's very important. It's a very important case to remember because the payments were very, very late. But that did not destroy the ordinary course defense. By the way, the court found that there was a preference. It's not. This is also always confusing. There was a preference, but the ordinary course defense succeeded in granting an exception to avoidance, even though there was a preference. I think the takeaway also is that, there was an expert in this case, in addition to ordinary course between the parties, that stated that it was ordinary course in the industry. After 2005, before 2005, you had to prove both that the payment was in the ordinary course uh, between the parties, and was also the norm in the industry. And here, that was the purpose of the affidavit. Now you don't need to prove both. You can prove either or both, but you don't need to prove both. Well, this is another case where you have a very late paying debtor paying out of terms, and the trustee argued that on average, the debtor paid substantially later during the preference period. By the way, this was a case by Judge Duberstein in the Eastern District, and I clerked for Judge Duberstein about 100 years ago, and a very funny man and a great judge. Okay, here the debtor was a distributor of Chinese food products. I'm not sure exactly what that means, whether they're perishable, or not, but I think what you're eating in a Chinese restaurant, that's what these guys provided to the restaurants. At any rate, the payment terms were 14, and the Chinese restaurant in this situation always paid very, very late. In fact, they usually paid over 100 days or more in the 9 years prior to the bankruptcy case, or prior to the preference period. What the court found was that during the preference period, the debtor made 4 payments, 104, 110, 112, and 115 days late. And in the previous 9 years, they paid all over the place, which is not uncommon, between 58 and 142 days. And the judge basically looked at this and said, they always paid very, very late, most of the time. So it's not unusual, and they paid within the range of the 9 year period. And the judge, even though the average was later, the judge didn't find that particularly relevant. Didn't find it relevant that they did more business during the preference period than they typically did in a 3-month period, and it just wasn't relevant. The judge basically said in his opinion, these guys always paid all over the place, and typically paid very late, and so it's in the ordinary course. This case was actually cited by a lot of cases. And it just shows that you can pay very late, as long as it's again showing you can pay very late, or you can get paid very late, and as long as excuse me, you can show that that's ordinary, you're still good under the ordinary course defense. Yeah. Also, there was no collection activity by Venus, so that was important. Also, Venus didn't do anything to get a particular advantage. Why? Because they were getting paid like they usually got paid. There was no reason to take any particular action. Well, what if you're defending a case and you find that the payments in the preference period are, not within the range of the payments of the base period? Let's say they're a little bit later than the range. So then you're dependent on doing, let's say, a comparison of the averages during the 2 periods. And what this case shows is that even though the average can be later, a court is not necessarily going to deny the ordinary course defense. These actually were payments to a law firm. The law firm was a defendant here, and basically the comparison was 54.7 day average during the preference period compared to a 38.4 day average during comparison period. So the trustee jumped all over this, said, well, the average is much later, so the ordinary course defense must be denied. There was one payment, as you could see, on October 27th, 90. That was 124 days outstanding, and that kind of skewed the average a little bit. Well, the court basically decided that it was not a significant difference between the two averages, not enough to take it out of the ordinary course defense, absent evidence of collection pressure or any other factors that would show activity in obtaining a preference. They were a little bit later, but the judge did not allow the ordinary course defense for the very late payment. Well, what happens when there's no base period? In other words, what happens when the only business that was done during the preference period? This is a case of a law firm that was retained and only did work right before the bankruptcy. The purpose of the work was to try to restructure the company so it wouldn't have to go file for bankruptcy and get and hopefully get additional financing. The financing did not go through, and the company filed for bankruptcy. Basically, the court, in its opinion, looked at the conduct of the parties. There was surprisingly no retention agreement, so it's not clear what the terms were. But there was testimony by the debtor basically saying, this is how we pay our lawyers, nothing unusual. This is a copy of testimony by the law firm's financial manager saying, again, that this is how we typically get paid. And there was testimony there. The bankruptcy court gave a lot of credibility to that, looked at all the facts, and basically didn't find anything out of the ordinary. The trustee argued, well, they paid in, the trustee tried valiantly to destroy the ordinary course defense by saying, well, the invoices were paid in batches, and that should take it out of the ordinary course defense. And the judge basically shrugged his shoulders and said, so what? And he quoted another case, which basically said, what's ordinary? I know it when I see it, and this is ordinary. And that was the conclusion of the opinion. A very effective way of showing ordinary course is to compare the range of payments, and I addressed this previously, between the comparison period, the base period, and the preference period. This is a case where a staffing agency was sued for a preference. They provided temporary employees, and it's an example of a successful ordinary course defense using the range technique. The trustee argued in this case that there were unusually large amounts of payments made in the preference period as compared to the base period. The judge responded by saying, hey, they did more business. So what? How is that relevant to ordinary course? They pretty much dismissed that. The defendant basically said in the comparison period, 90% of the transactions were between 30 and 60 days. And in the preference period, they were paid between 30 and 60 days. So it's just a classic range comparison analysis. The court agreed and found ordinary course. Payment by wire or certified check or any sort of emergency looking type of payment sort of raises red flags in the preference case. That's done during the preference period. But it's not always because of extreme collection pressure, and sometimes it's common between the parties. So this is a case, very recent case, and the judge found that There were wire transfers that were made during the preference period. And the question was, the trustee argued, hey, there are wire transfers, Your Honor, it's out of the ordinary course. Now, the other argument made by the trustee was there was an email sent by the debtor inquiring about payment, and an allegation that the defendant knew at the time that the debtor was going to go bankrupt. The court basically found that, wires were common, and that's very, very important, that they paid by wire prior in the comparison period, and that there was no demand for a wire, and the debtor basically voluntarily paid by wire, and so the court found that just because there was a wire by itself, it was not enough to take this. Was not enough to destroy the ordinary course defense, and the judge granted the ordinary course defense here. Okay, we're going to jump to the last element of the ordinary course defense, 547C2B, made according to ordinary business terms. That refers to what is commonly known as the industry standard defense. I'm going to go into that a little bit. What we also need to know is that the law has changed in 2005. That used to be, instead of an or at the end of a, that was an and so it was actually much harder to prove the ordinary course defense, because you had to prove that the transfer was ordinary between the parties and comported with an industry standard. But it's been made easier by the changes in 2005. Well, what does that mean? What does an industry standard mean, and how do you prove it? In this case, there was a wire transfer, well over $1 million, so it's a fairly large case. Both the defendant and the debtor were in the business of buying and selling electricity, and so they were in the same industry. It's interesting to me a little bit that there was a wire transfer. That tells me that possibly it wasn't ordinary, it was not ordinary between the parties. Maybe the wire made that element of the defense unavailable, and so the focus was on proving industry standard. The defendant had its credit manager testify. Apparently did not retain an expert, and testified as to the invoicing, as to the payments, as to the normalcy, as compared to normalcy of the transfers as compared to business with other clients and other customers. Basically said it was commonplace in the energy trading industry. The judge accepted the evidence, and there was no other evidence put forth contradicting that, which I'm a little bit surprised by. So for whatever reason, apparently the debtor did not retain an expert, and no one contradicted this evidence, and the judge ruled that the transfer was in the ordinary course using the industry standard. A very important question with industry standard is how the evidence is going to be presented. Sort of a sub-issue of that is the issue of whether testimony by a layperson is acceptable, either by affidavit or testimony in court or declaration. And why is this important? Because it's extremely expensive to hire an expert. And so if you can have someone on your staff or an officer testify or just do an affidavit, it's going to be a huge advantage for the defendant. This is a case where the debtor sued a provider, an IT consultant, and the question came up, can the industry standard be proven by an affidavit? This was actually a motion for summary judgment, not even a trial. The short answer is the defendant submitted a motion for summary judgment supported by a couple of affidavits. One of them was the defendant's controller. The trustee argued that, hey, Your Honor, this is not an expert. This person's opinion is not admissible, and so this needs to be thrown out. The judge basically granted the summary judgment motion and ruled that the declarant had personal knowledge of the statements that he made in his declaration, and therefore he did not need to be an expert, and the evidence was admissible. So it's very, very important to know that you could submit an affidavit, a declaration, and actually win on the fact issue of whether the transfers comport with the industry standard. Another way to prove the industry standard defense, part of the ordinary course defense, is information from D&B and RMA, the Risk Management Association. In this case, the defendant relied on the industry standard part of the ordinary course defense and submitted data from the RMA. Short answer is yes. The court found it to be convincing evidence, and this is very important because it's an extremely inexpensive way to show the industry standard if the court accepts this as evidence. This particular court did.